Hey everybody, good to be here. It's actually on a Sunday afternoon, so got a lot to cover. A lot of new stuff. Let's jump right in. First thing I'll do, tell you a little story about myself. As it relates to estate planning, I started getting involved in estate planning when I was 8 years old. That's 51 years ago. So my grandmother passed away. My grandfather had predeceased her, and my grandmother left me a few shares of stock. And so when I was 8 years old, I inherited that. It was in a custodial account. My father was the custodian, but I was able to kind of watch that stock and keep an eye on it. What it did was it enabled me to go to college, go to law school, earn my master's degree in tax law, get a little bit of a head start on life. So been involved in estate planning for a long time. Kind of, oh, by the way, my wife and I have 5 kids. And quick story about my 5 kids. As my kids were trying to figure out at that age where they were trying to figure out what they wanted to do with their lives, I sat them all down and I really said, look, don't go to law school. Find something you're passionate about. Law school, it's a lot of school. You really won't get started on your life until you're in your mid to late 20s. Find something you're passionate about and go for it. So as a result of those conversations, 3 of my kids are lawyers and the other 2 are in law school. So that's how that worked out. Anyway, and by the way, one is married to a lawyer. One last night got engaged to a lawyer, and another one of my kids in law school is dating a law student. So a lot of lawyer action going on. All right, let's jump in. IRS announces increased 2025 estate and gift tax exemption. Hey guys, Lisa and others joining in the chat. I love to do the live stream because it enables you to put in your thoughts, experiences, questions, comments in the chat. Of course, we keep it positive, but feel free to contribute. Love to see that. I usually address that towards the end. Who is this live stream for? Could be for a lot of different people. Maybe you've accumulated some assets, or maybe you plan to accumulate some assets. And we'll talk about how much when we talk about, what does it mean to accumulate some assets. And you want to make sure that those, are preserved. They stay in the family, keep it in the family, keep it in the bloodlines, less to the government. And so that's your mindset. You want to know what people are doing. You want to know what the legal strategies are. You want to know what makes sense. Maybe you're on this because you heard some laws have changed. And really the title of this live stream suggests that there have been some adjustments to some of our tax laws. But really, maybe you heard that in about a year, there's going to be some major changes going on with our tax law, barring Congress taking some action. I was just watching a news report a moment ago where, we've got an election in a couple of days, not just the presidential election, but of course, Congress, the Senate, the House of Representatives, and that's who makes the laws, the Senate and the House of Representatives. So one journalist was arguing that maybe if one party controls the whole thing, then maybe they can get some things done, because if one party doesn't control it all, things just get stalemate, things don't get done. This isn't a political discussion. Just we'll talk a little bit later about how the tax laws will change drastically unless there's some congressional action, in the next year or so. All right, so here we are. Let's just jump right into the numbers. The numbers, really, I want to tell you what the numbers are and how they've changed, but that really doesn't mean much. What really means a lot is, okay, what does that mean to you, and what does that mean to your family? So here's the numbers. We have what's called an estate tax exclusion amount. Sometimes it's called an exemption amount. Sometimes it's called a basic exclusion amount, BEA. And really, this estate tax affects the wealthier folks. Now, we're going to talk about a lot of things, income tax, capital gains tax, that affect you regardless of whether you're in that estate tax category. But the numbers that changed are, we have this basic estate tax exclusion amount, which is the amount of assets that you can give or leave to others when you pass away without being subject to the roughly 40% federal estate tax. Here in 2024, the basic exclusion amount is $13.61 million. They just came out with the adjustments. It gets adjusted for inflation every year. In 2025, the numbers is the basic exclusion amount, the estate tax exclusion amount will increase from $13.61 million to $13.99 million. Yes, I wish they would have just made it 14, but they made it 13.99 million. I don't know how many conversations I'm going to have over the course of the next year where, when I have a serious discussion with somebody about estate tax planning, I'll have to say 13.99 million about 10 times in every conversation that I have. I wish it was just 14 million, but so be it. All right, so that number changed. Also, the gift tax annual exclusion amount increased by $1,000. It's been increasing just about every year. It only increases in increments of $1,000, and it only increases by $1,000 if the inflation adjustments kind of warrant that. So yeah, 2024, the gift tax exclusion amount is $18,000. Next year, it'll be $19,000. So let's talk for a minute basics here on how the $19,000 gift tax exclusion amount is unified with the $13.99 million estate tax exclusion amount. Let me give you an example. Let's say dad, for whatever reason, he wants to make a large gift to, let's call it his daughter. Maybe he just wants to give her money to pay off her student loans or put a down payment on a house, or maybe he wants to give her a piece of land that has value, or maybe he wants to start an investment account for her. It doesn't necessarily have to be a gift of cash. It's a gift of anything of value. But let's say dad wants to enable his daughter to buy her first home, and I'm going to come up with a number. Let's say he wants to give her $219,000. So he writes her a check in 2025 for $219,000. All right, so we know in 2025 the gift tax exclusion amount will be $19,000. But and so everybody kind of thinks, well, nobody owes any tax if somebody gives $19,000 or less. But dad gave daughter $219,000. So who owes tax? Actually, nobody. So it has nothing to do with the income tax. Has everything because a gift is exempt from income tax, but it has everything to do with the unified gift and estate tax. So by dad making a gift to his daughter of $219,000. First $19,000, it falls under the 2025 $19,000 gift tax annual exclusion amount. But the excess $200,000, now what dad has done is, nobody owes any tax, but dad has now, once he makes that $219,000 gift in 2025, he has used $200,000 of his $13.99 million estate and gift tax exclusion amount. So now when dad dies in later years, assuming he made no other taxable gifts, or assuming he dies later in 2025, he will only be able to leave $13.79 million free of the estate tax instead of $13.99 million free of the estate tax. So when people hear that explanation and they're considering making a significant gift to their child, maybe $100,000, maybe $50,000, maybe something more than what is now what will be next year $19,000 annual exclusion amount, people get worried. Oh, geez, there's going to be a bunch of tax owed. There's going to be a bunch of tax consequences. But normally, unless the donor is wealthy, once I explain that, hey, nobody's going to owe any tax, if you do give your daughter $219,000, you're just going to use up some of your $13.99 million estate tax exclusion amount. Sometimes you'll see dad just say, well, I'll never have that much anyway, so it's not an issue. Now, we'll talk a little bit later how there's going to be some major changes in the estate and gift tax exclusion amount coming in the next year or so, but we'll get to that in a minute. But at least now you know how the gift tax and estate tax exclusion amounts are kind of unified or connected. All right. So a couple of other kind of estate tax planning 101 rules that you need to know about. Let's talk about what's something called portability, been around about a dozen years or so, maybe a little bit more. Something called portability. So portability is really a great thing. So it really, in many cases, enables a married couple to double the amount that they can leave free of the federal estate tax. I'm going to call the 2025 $13.99 million estate tax exclusion amount. I'm just going to call it $14 million. It rolls off the tongue easier. But what a portability election does is it, not in every case, but in many, many cases, it does enable married couples to exempt not just 14 million from the estate tax, but 28 million from the estate tax, because each spouse has their own exemption. Portability allows married couples to really double up on that. Let me give you an example. Let's say a married couple has, let's call it $16 million between the two of them. And let's just keep it simple. Each of them has an $8 million estate. And let's really keep it simple. And let's say the husband dies and he leaves his $8 million to his surviving wife. So she now owns the entire $16 million. Well, because he left his $8 million to his wife, she has the whole $16 million now. $16 million is more than $14 million. So when she dies, part of her estate will be subject to the 40% federal estate tax. And to get a little bit technical on the rules here, when the husband died, leaving everything to his wife, his gross estate was $8 million, but he left it all to his wife. Anything you leave to your spouse, your estate gets a deduction for anything you leave to your spouse. It's called the unlimited marital deduction. A little more on that later. But dad's gross estate was $8 million. He left it all to his wife. So his estate gets an $8 million deduction because it all passes under the marital deduction. Dad's net estate is zero. Mom's estate is $16 million. You think, boy, when mom dies, her estate's $16 million. She has a $14 million estate. Oh, by the way, that her exemption may be $7 million if she lives another year. So this starts to get to be a big deal. More on that later when we talk about the sunset of the Tax Cuts and Jobs Act, which is coming. But mom has a $16 million estate because dad left his $8 million to her. She had her own $8 million. She got his $8 million. Now she has 16 estate tax when she dies. However, what a portability election allows is if after dad dies and they meet all the timely filing requirements, even though and federal estate tax return was not required to be filed with the IRS after dad died, because it's only required to be filed if dad's gross estate exceeds the exclusion amount. He had $8 million, exclusion amount $14 million. No requirement to file a federal estate tax return. The IRS says you don't have to let us know anything. However, if his estate, and probably led by his surviving wife, who might be the executor of his estate, files a federal estate tax return, it's called IRS Form 706, and makes this portability election. See, the husband's estate tax exclusion amount is portable to the surviving spouse. He didn't use any of his estate tax exclusion amount. His net estate was zero, gross estate $8 million, left it to his wife, marital deduction $8 million, net estate zero. He didn't use any of his $14 million exemption. But because an estate tax return was filed timely after dad died and the portability election was made, now mom has her $14 million exemption, or whatever the exemption will be when she dies. Plus, she'll be able to use dad's unused $14 million exemption. So that should be enough to shield her $16 million estate from any of the 40% federal estate tax. So oftentimes, the first thing that you want to look at when a relatively wealthy married person dies is, hey, do we need to, even though an estate tax return may not be required to be filed, do we want to file one anyway in order to make the portability election so that the surviving spouse will not only have their exemption, but they'll also get to take advantage of the estate tax exemption that the first spouse to die didn't use. Okay, so there's a lot there, just portability. Okay, another kind of let's make sure we do the right things, kind of basic estate tax planning for married couples. Again, this one hits the wealthier couples. It's called a QTIP trust. There's some tax reasons we use something called a QTIP trust. Forget what QTIP means, qualified terminable interest property. It's a legal mumbo jumbo. And then there's some non-tax reasons married people use a QTIP trust. Some of the non-tax reasons people use a QTIP trust, and again, forget about what QTIP means, but some of the non-tax reasons, let's say a husband dies with that $8 million estate and he's not comfortable leaving that $8 million to his surviving wife because he thinks or he's concerned in the back of his mind that his children may not wind up with any of that. So, she might get remarried, leave it to her next spouse, leave it to the proverbial pool boy or whatever, or just get influenced by someone, one stroke of a pen, and his children get disinherited. So what the husband can do in those circumstances is he can leave his $8 million estate or whatever it is when he dies to what's called a QTIP trust. Maybe his wife is the trustee after he dies. His wife gets the income off of those assets for the rest of her lifetime. Maybe she can even access the principal if she needs it. But when the wife later dies, what's left of the husband's estate automatically reverts back to the husband's children. The surviving wife can't change where the husband's part is going to go when that surviving wife dies. She can only control where her $8 million or whatever it is going to go. So those are some non-tax reasons married people use QTIP trusts. However, with in 2025, with a $14 million exemption, let's say the husband's estate is larger than $14 million, and he doesn't want to just leave stuff in outright ownership to his wife. He can leave assets to a QTIP trust. Let's say he has a $20 million estate. You'd think there'd be estate tax due on that excess $6 million, but if he left that to a QTIP trust, that qualifies for what's called the marital deduction. And so he left it in a trust for his wife, and when his wife dies, it goes to his kids, and his estate gets a deduction. But for that, from 20 million, let's say he did 6 million of it that way, that would reduce his net estate down to 14 million, no estate tax when he died. Those assets that qualified for the marital deduction, yes, they'd be included in the surviving wife's estate. So two legal mumbo jumbo terms, but kind of basic estate tax planning. One term, portability, allows the surviving spouse to use the deceased spouse's unused exclusion amount. And two, QTIP trust, where if the first spouse to die has a large estate, it's a way to virtually guarantee that there will be no estate tax that's due after the death of the first spouse. Assets that would have been subject to the tax simply get added to the surviving spouse's estate. And maybe the surviving spouse's estate will not be large enough to warrant estate tax when the surviving spouse dies. So those are just some, hey, let's make sure both spouses use their estate tax exemption. Okay. Now I want to get into some issues that that affect the modest families. We'll be talking about some capital gains tax issues, some income tax issues, and we'll be talking about the sunset of the Tax Cuts and Jobs Act. Okay, so let's talk about capital gains tax. This one really hits everybody, especially as we see the stock market increasing and people's stock portfolios are appreciating in value. We're seeing home values rise. And so things like that are subject to the capital gains tax when they are sold or disposed of. Rental property gets sold, for example. So there's it's called a step up in basis. It's a beautiful thing. You got to die to take advantage of it, but almost worth the price there. So the basic capital gains tax step up in basis rule. Let's look at a issue. Let's say you purchased some shares of stock. You name the company, Apple, Microsoft, NVIDIA, you name the company, but you purchased shares for $100 a share. Now those shares are worth $400 a share. So there's $300 of capital gain. You don't owe tax on that, though, until you sell those shares of stock. But if you bought it for $100 and you sold it for $400, there'd be $300 of capital gain. You owe capital gains tax on that. However, the basic step up in basis rule says if you don't sell the stock and you simply die with that stock in your estate, then your heirs will inherit that stock with a step up in basis. You bought it for $100 a share. If you sell it during your lifetime, after it's increased to $400 a share, there's $300 of capital gains tax. You'll owe, I don't know, depending upon the state and federal levels, maybe 20 or 25% capital gains tax on that $300 of gain when you sell it. But if you don't sell it and you just leave it to your heirs will inherit it at the step up in basis. Now, their basis will be the value of that stock on the date that you died. Let's say it was worth $400 a share when you died. That's going to be their new basis. So when they sell the stock, again, only the capital gains tax is only due when stock is sold. They may not sell it for a while. They may not ever sell it. So they certainly don't owe any tax when they inherit it, at least no capital gains tax. But their basis will be $400. That $300 of appreciation just gets wiped off the books from a capital gains tax perspective. All right, so here's the deal. The capital gains tax and the step up in basis affects most families. This has nothing to do with the estate tax, nothing to do with the $14 million estate tax exclusion amount. This applies to all people who inherit stock and all people who leave behind appreciated assets. There is a rule if you do live in one of the community property states that you do need to be aware of. It's an extra bonus for couples who live in community property states, because the step up in basis rule for couples who live in a community property state like myself, I live in Louisiana, is when the first spouse dies, not only does the deceased spouse's share of the community property get a step up in basis, all of the community property, including the surviving spouse's share, all of the community property gets a step up in basis. So yeah, if during the marriage, Fred and Wilma Flintstone bought 1,000 shares of ABC Inc. stock, and Fred owns 500 shares and Wilma owns 500 shares, and after they buy the stock, it shoots up in value. Then when Fred dies, if he lived in a community property state, not only does Fred's 500 shares get a step up in basis, but Wilma's 500 shares get a step up in basis. So it really is an opportunity for married couples, especially if they're later in life and they have some assets that have appreciated significantly in value. You're going to see a lot of married couples just hold on to those assets. They don't want to sell them. They don't want to incur the capital gains tax. But if they live in a community property state, when the first spouse dies and all of the community property gets that step up in basis, you see a lot of surviving spouses sell appreciated assets at that time because the basis was reestablished upon the date that the first spouse died. Also applies to homes. If some married couple bought a home 40 years ago for $100,000 and now it's worth $900,000, and the husband dies, for example, if they lived in a community property state and it was community property, then the new basis would be $900,000. That surviving wife can sell that home for $900,000 without incurring any capital gains tax. In fact, she can sell it for $1,150,000 because there's a special rule when you sell your home where if you're single, you can exempt the first $250,000 of gain from the capital gains tax. So lots of rules here. But I do want you to be aware of the step up in basis and how it affects people. Now, how you leave your estate affects how much capital gains tax your survivors are likely going to have to pay when they sell assets that they inherit. So let's take the example of Fred and Wilma Flintstone, and they do have the $16 million estate. Each of them owns $8 million. So from a capital gains tax perspective, and look, we don't take all of our actions and we don't take all of our estate planning actions based solely on what the potential tax results might be. There's a lot of non-tax factors that go into estate planning decisions that have nothing to do with tax, but those non-tax factors need to be considered. Fred's saying, do I want to leave it all to Wilma? Do I want to leave it in trust for Wilma? Do I want to leave some to my kids if I pass away first? So those are some of those non-tax decisions. But if Fred and Wilma have the $16 million estate, each of them owns $8 million, and Fred does leave everything to Wilma, and all of it goes into Wilma's estate, then that's actually a good thing for capital gains tax purposes, which is one of many things to consider. Because if Fred leaves everything to Wilma, well, if Fred lived in a community property state when he died, all 16 million would get a step up in basis. If Fred did not live in a community property state, then Fred's $8 million would get a step up in basis, and Wilma's $8 million of assets, the basis would not be stepped up when Fred died. But if Fred left it all to Wilma, and Wilma had the entire $16 million, and it was all in her estate, then let's say Wilma lives another 20 years, then all of those assets will get another step up in basis when Wilma dies. And if when Fred died, they filed the estate tax return that I talked about earlier, they made the portability election, then Wilma's going to get 2 estate tax exemptions. So that kind of perfect scenario is when married couples can set things up where there's no federal estate tax because they set up their estate and made the proper elections when one of them died. So they get to fully utilize 2 estate tax exemptions. So that's part one to making sure married couples take advantage of the tax code is do what you need to do to avoid the estate tax. And look, oh, by the way, for the really wealthy couples, to avoid estate tax, some married couples will want to start getting things out of their estate before they die. But be that as it may, the kind of way it works out for many couples who are not really wealthy is they can keep everything in their estate, and because they set things up properly, their estate falls within the 2 estate tax exemptions. So 0 estate tax when the first spouse dies, 0 estate tax when the first spouse dies, and because they left everything in their estate, they get what I call this double step up in basis. Because if you start transitioning assets to your children or others while you're alive, your children or others won't get that step up in basis when you die on those assets that you transition to them during your lifetime. That gets a carryover basis if you give assets away. If you give a share of stock that you purchased for $100 and is now worth $400, if you give that share of stock to your daughter before you die, you give that to them during your lifetime, they get what's called a carryover basis. Their basis will be what your basis was, $100 a share. They won't be able to take advantage of the step up in basis. They'll get whacked whenever they sell that share of stock. So ideally, in many cases, you're seeing many married people leave assets in the estate based on the large estate tax exemption, which is not going to be large in the next year when I get to that. But also take advantage of the step up in basis by leaving the assets in the estate. So there's a few little games you have to play, and obviously you have to project and kind of make some educated guesses as to how much will our estate appreciate over time, guesses as to what will the estate tax, the capital gains tax rules be in the future. That's a really tough one. But just want to kind of let you know what goes into making some of your estate planning decisions. On the other hand, if Fred said, I don't want to leave my estate to Wilma, even though by leaving my estate to Wilma, she may live another 20 years, it'll all get another step up in basis when she dies. Fred may say, I want to leave my estate to a trust for Wilma to give my kids more protection, so that my kids are more likely to inherit those assets when Wilma dies from that trust. Now, those assets that are left in trust for Wilma, in many cases, those assets don't get another step up in basis when Wilma dies because those assets are not in Wilma's estate. So there's that, again, that whole kind of estate tax, capital gains tax kind of gamesmanship that goes on when we're in the estate planning process. Decisions have to be made correctly now while the married couple is setting their estate up on how they not only leave things to their children, but how they leave things to each other. So got to make those decisions right. And then also have to make the right decisions and elections when the first spouse dies to make sure you take advantage of all the rules that you can take advantage of. Okay, I see the chat. I'd love to be able to answer them all, but I'm going to get to them so I can Haven't quite learned how to do more than one thing at a time yet. Still working on it, but let me keep going. A few other things. As we get into 2025, I may be putting the cart before the horse here, but we want to make sure that your financial power of attorney, or whether it's called durable power of attorney or your living trust, you want to make sure you give the proper people the authority to do the gifting that they may need to do now that our estate tax laws will be changing, as I'm going to discuss probably in about 3 minutes, as the Tax Cuts and Jobs Act expires or sunsets on January 1, 2026. More on that in a minute. Okay, let me give you another couple of recent announcements from the IRS that affect, people who are putting their legal affairs in order. And I have a lot of sympathy for people who they've worked for 20, 30, 40 years to accumulate assets. They've been just getting after it. They haven't been keeping up with all of these estate rules that I have to keep up with. So it's okay if you don't even know the basics. And that's what I like to cover here is let me just cover what everybody needs to know, and then we'll go from there. But some other IRS announcements that have been made, it has to do with the income tax. And a lot of confusion out there among people as to trusts and income tax. Let me give you some numbers, and then I'll talk about how it applies. So for 2025, we have, I'm not even exactly sure how many tax rates we have. I think it's 7, with the top rate being 37%. And married couples filing jointly will pay federal income tax in 2025 to the extent that, they'll pay it at the top 37% rate when their income, taxable income, exceeds $751,600. That's a pretty big number. So if you're a married couple and your taxable income in 2025 is under $751,600, you're not going to be paying federal income tax at the highest 37% tax rate. Only that income that exceeds that gets paid at 37%. Now, here's where people start to get confused, because trusts also have income tax rates. They have the same 7 or so rates. The top income tax rate for a trust is 37%. However, a trust pays federal income tax at 37% when that trust income exceeds a much lower number, $15,650. That's the 2025 number. Every year I get a few calls from the financial advisor or the CPA or somebody that says, Paul, what are you doing? You are crazy. You're helping somebody set up a trust. Yeah, I hear it's a revocable living trust, and I know that, they want to avoid all of the court and lawyer involvement of probate. But those assets in their revocable living trust are going to have much more than $15,000 of income, and they're going to have to pay, 37% on all of that income, where if they just left all of those assets in their name, they wouldn't have to pay income tax at 37% unless they have more than $751,600 of income. And so I have to give this saying, this little explanation over and over again. And the explanation is real simple. Very, very clear in our tax rules, our tax regulations. Assets in a revocable living trust, and most people who set that up or setting that up so that, because assets in that trust don't have to go through the court and lawyer involved probate process when they pass away. They designate a trustee who can distribute the assets immediately when they die without lawyer and court involvement. So the IRS rules are clear. A revocable living trust is, for income tax purposes, called a grantor trust. So when you have assets in a grantor trust, the trust doesn't file an income tax return. The trust doesn't pay any tax. All that income from the trust accounts here, for example, just flow through to your personal return. So when people kind of get up in arms, whether it's the financial advisor, the CPA, the lawyer, and they're like, don't do a revocable living trust because that income from that trust is going to be taxed at a higher rate. And in most cases, they're just wrong, and they don't understand the rule, the grantor trust rules. Okay, so just clearing that up for you. I always have to have those conversations and clear that up for folks. Okay, so now let's get to the sunset of the Tax Cuts and Jobs Act, which was passed about 9 or 10 years ago. And the idea behind that, all of that is tax laws were passed that reduced the amount of tax that individuals and estates had to pay. And when laws are passed reducing the amount of estate tax that estates will have to pay, well, those laws that reduce the tax typically increase the exemption. So for the last 10 years, our exemption has been creeping up and up and up from 10 million, and it's been increased for inflation. It was at 5 million adjusted for inflation, and now it's up to $14 million for 2025. But because the Tax Cuts and Jobs Act sunsets or expires on December 31st of 2025, now we have to go back to the tax laws that were in place right before the Tax Cuts and Jobs Act was passed 9 or 10 years ago. And the law at that time was the estate tax exemption was $5 million adjusted for inflation. So for 2025, we're going to have a $14 million basic exclusion amount, which really is $10 million adjusted for inflation a whole bunch of times. And so when 2026, we're going to go back to $5 million adjusted for inflation a bunch of times. The way I look at it is, if in 2025, the exemption is $14 million, we know it's 13.99, I call it 14 million. And it went up in 2024 from 13.61 to, from 2024 to 2025, it went from 13.61 to 13.99, an increase of about $400,000. Then that inflation adjustment for 2026 would have increased it from about 14 million to about 14.4. So I'm guessing, assuming no congressional action, that in 2026, the basic exclusion amount will come back from $13.99 million to somewhere around $7.2 million or $7 million and some change, after it gets cut in half and then adjusted for inflation again. So I will tell you another lot. I'm going to have, because I've had a bunch of conversations this year about it. Hey, I hear the exemption is being cut in half. What do I need to do now to take advantage of it? Bottom line on there, it's a kind of, I call it a go big or go home kind of argument, because for people who die in 2026 or later, their estate tax exclusion amount will be the greater of the exclusion amount in the year that they died. Let's say they die in 2026, and when the exclusion amount is $7.2 million, that's going to be their exclusion amount. It's the greater of that amount or the amount of the exemption that they used during their lifetime. So the really wealthy people, you know, if I had $100 million estate and I could give away $14 million this year, and I wanted to give it away to take advantage of the tax laws, and I was married and she also had a $14 million estate, you'll see the people maybe with that the married couple with the $100 million estate say, well, we want to take advantage of this $14 million exemption while we have it, because if we don't take advantage of it during our lifetime by making a large gift, it's going to get cut in half and we'll only be able to take advantage of half of that when we die. So the $100 million estate people may choose to give $28 million to their children. And so that's 28 million plus all of the appreciation on that in subsequent years that will never be subject to the 40% tax. If they don't do it, then each spouse will be subject to their $7 million exemption or whatever it will be when they pass away. So I'll have lots of conversations this year about people trying to figure out what to do. All right. Now, all this is based on Congress taking no action. Yes, here we are, November 3rd. We've got a big election in 2 days. I don't even know that the presidential election is the most important election, when it may be the most important single election, but the president doesn't really make the laws. It's the Congress that makes the laws. And so these, the Senate elections, the House of Representative elections, which party has the majority? Does a party control both houses of Congress? Those are all things that will factor significantly into whether Congress takes any action to do something different than what is on the books, which says that the estate tax exemption will be cut in half on January 1, 2026. We got a mouthful here, but we're rolling. Okay. So if all this has got you thinking, boy, I'm not getting any younger, may need to get serious about putting some things in place, let me just give you a quick 30-second version of how we've helped people over the years. Again, I mentioned at the very beginning of the presentation my story about how I inherited some stock when I was 8, got me through law school, got me, I earned a master's degree in tax law after law school from Boston University, and started working for some big law firms 25 years ago or something like that. I started my own law firm, helped a lot of people, started in Louisiana. It's where I lived, started making these YouTube videos about 8 or 9 years ago, and they took off. And so people started contacting me from all over the country. I created a law firm now that we're able to help people around the country because we utilize this co-counsel network that I've built, where there's a lawyer who participates in, whether it's New York or Florida or Tennessee or wherever you live, and we're able to help people around the country. It all starts with a Zoom meeting with me. People can click on the link in the description to request that Zoom meeting with me. We ask you a few questions. About half of the people who fill out that kind of request form kind of make it through and get my calendar link to have a Zoom call with me. But some of the people we have to screen people. For example, I think I saw a request for a meeting with me come through last week, and it said something like, "Hey, Paul, been watching your videos, love your videos. I got a big estate issue I need you to help me with. My dad passed away 2 weeks ago, and my stepmom went into his house and stole his entire Tupperware collection. I need to sue her and get that Tupperware collection back." And so, those are the ones that we just don't help. We can't help. We don't handle that, estate litigation stuff. But the kind of stuff that we do help people is get their estates in order to avoid problems on the backside. So, by the way, if you haven't any interest in having a Zoom conversation with me to talk about maybe what's the easiest and simplest way to get your estate in order to take advantage of all these things that you can take advantage of, feel free to click the link in the description below. Okay, so the summary here real quick. New IRS just announced it, I think it was last week, new $13.99 million estate tax exclusion amount, $19,000 gift tax annual exclusion amount. The 13.99 was increased from 13.61 for 2024. The 19,000 was increased from $18,000 from 2024. Given that, though, married couples still need to be aware that when the first spouse dies, there may need to be an estate tax return that should be filed, IRS Form 706, even though it's not required to be filed, but it does need to be filed if the married couple and the surviving spouse wants to take advantage of the first spouse to die's unused estate tax exclusion amount. We have the QTIP trust, which allows married couples to not have to pay any tax when the first spouse dies, even if the first spouse to die had an estate that was larger than the applicable exclusion amount. Taxes generally get deferred until after the surviving spouse dies. They've written these estate tax laws really to set it up so if married couples plan properly, there's no estate tax on 2 times the exemption. And if they have more than that, it's not due until 9 months after the surviving spouse dies. We do have this capital gains tax. Any real serious estate planning discussion ought to address, hey, what's the future capital gains tax consequences when I pass away and my survivors, whether those survivors are your spouse, your children, your grandchildren, or others, there needs to be a discussion. What's the capital gains tax consequences to them when they ultimately sell assets that I leave them? And is there anything that I can do in setting up my estate to minimize or eliminate that capital gains tax burden? That's a big deal. And then 2025 is going to be a crazy year, because at the end of 2025, the Tax Cuts and Jobs Act, which has been on the books for about 10 years, it's going to expire, bringing all the tax laws that were in place 10 years ago back into place now. So it's going to be nuts. And then just click the link in the description if you want to request a chat. Let's go. Speaking of chat, let's go to the chat. Why so much of an exemption? If they have 14 million, let someone. So there you go, Barb. There's Barb's position. Barb, not 40%. Hi, Bella. Let's see. Does the IRS ever ask you to prove you only gave the annual exclusion? I have given the exclusion amount several times and wonder if I should be saving paperwork in case the IRS requires proof. I'll answer the second part first. Yeah, you should be saving documents. Now, our gift tax filing requirements, they're like the income tax filing requirements. The income tax, it's a voluntary reporting system. If you go out and work for someone and you make $200,000 in a year, you are required to voluntarily, file your income tax return to show that you earned $200,000 and you pay the tax on that. Well, the gifting is similar, although with gifting, there's often not tax due. But filing the gift tax return is, it's on the donor, the person who's making the gift, to file the return. Now, if your gifts fall within the annual exclusion amount, there's no requirement that you file the return. And if your gifts exceed the annual exclusion amount for a year, then there's still no tax due, because you're using your exemption by making gifts in excess of the exclusion amount. And penalties for failing to file a gift tax return are based on a percentage of the tax due, and often there's never tax due when you're filing a gift tax return. You're just showing that you're using some of the exemption. By the way, the gift tax return is IRS Form 709. So, but you should, because when you pass away, if there's an estate tax filing requirement, when you pass away, on your estate tax return, which should be filed within 9 months after you pass away, they have to show a history of all of the prior gifts, at least the taxable gifts that exceeded the exclusion amount. So yeah, the more documentation you keep on that, the better. Pros and cons of revocable and non-revocable trusts. Bella, that's a whole nother live stream there, but I'll answer it in one sentence. Many people use revocable trusts, which is Fred and Wilma Flintstone set up the Fred and Wilma Flintstone Revocable Living Trust. Their trust says they can do whatever they want to with the trust assets as long as they live. They can keep them, sell them, give them away, no restrictions whatsoever. And all those assets remain in the estate of Fred and Wilma, so there's no tax advantage or disadvantage to Fred and Wilma setting up their revocable living trust. But the primary reason people set up a revocable living trust is so that they can retain control over everything that they own for the rest of their lifetime, but set it up in a way, because things that are in a trust when you pass away, they don't have to go through that court and attorney involved probate process through the court system. When you pass away, assets that are in your name, perhaps your home, a business you may own, maybe stock that you own. I'm not talking about your retirement accounts and life insurance that have beneficiaries designated, but often people die and they have assets that are frozen when they die. Those assets are in their name. So the survivors have to go through what is often an expensive, time-consuming, and an all-around hassle probate process. By transferring assets to what's called a revocable living trust, your survivors, it'll be a much more streamlined estate settlement process, because nothing has to go through the courts to be distributed from your trust to your trust beneficiaries or heirs after you pass away. Non-revocable trust often are tax driven. So this is a very general statement, but you're asking, Bella, about non-revocable trusts. So oftentimes people will transfer assets to trusts that cannot be changed. So they're non-revocable. They're giving up, these people who are setting that up and transferring their assets are giving up some level of control over those assets. And probably it's set up so that the people who transferred assets to an irrevocable trust don't have the right to get those back. But they gained some advantage by setting that up. Maybe it's an income tax advantage. Maybe it's a future estate tax advantage. Maybe it's a qualify for long-term care Medicaid advantage if they go into a nursing home in the future. So a lot there. I'll have to do a live stream. Bella, look out for my what's the pros and cons of revocable and non-revocable trust. Whiskey Business Bar, that money has already, yeah, you're right. Whiskey Business, you're right. By the time someone's assets are hit by the estate tax, they've been taxed a lot of different ways: income tax, sales tax, property tax, capital gains tax. So you're right. Two sides to that argument for sure. Let's see here as we go along. Testator has only life insurance, less than 500,000, lives between two states. How to know under which state's laws to establish and which state's laws will prevail if. Okay, so usually it kind of depends on your state of domicile, and that's a facts and circumstances test. Where do you spend most of your time? Where do you vote? Where are your vehicles registered? So you got the Virginia and Pennsylvania there. So that would just require more discussion. Again, no hard line tests, but more of a facts and circumstances test on where someone is domiciled when they pass away. And we often like to set up people's trusts in the state where they are domiciled. Just a little cleaner that way. Parents' grantor revocable living trust passes assets to 4 beneficiaries, 4 sons, into 4 separate irrevocable trusts. I like your emphasis on irrevocable. How is the tax handled when we boys receive the trust assets? Thank you. All right. So, Mike, here's the deal. Let's say parents have $4 million of assets, and it's probably a wide range of assets. You probably got a home. There might be some IRAs, might be traditional Roth, might be a brokerage account, vehicles, all kinds of other assets. Kind of have to look at each different asset to determine the tax consequences. Let me get this out of the way. If you inherit a traditional IRA, now that's not in their trust, but I'm just telling people out there that when they inherit or are the beneficiaries of a traditional IRA or a traditional 401k, pre-tax IRA, those beneficiaries are going to have to pay income tax on the traditional IRA assets that they inherit. However, if they inherit, real estate or bank account money that's in a checking savings account, CD, or stock that's not in a retirement account, that all goes income tax free to those beneficiaries. Now, you said it went into 4 separate irrevocable trusts. So one of the first thing I'd do is let's look at the terms of that irrevocable trust. Do those irrevocable trusts, does it permit the income from those trusts after mom and dad die to be, or does it require that the income from those trusts be distributed to the beneficiaries each year? If so, then all the 4 boys will pay income tax on that income that gets distributed to them from their trust. If the trust requires that the income after mom and dad die of those trusts gets accumulated in the trust, now the trust is going to pay the income tax, probably at higher trust income tax rates. So the terms of the irrevocable trust are important, but generally speaking, as distributions of principal are made to the sons from those trusts after the parents died, those principal distributions are income tax free. There's only income tax consequences based on the income that the principal produces. Okay, that was a mouthful. Is there a chart? If you get through the screening, Lisa, and we're going to ask you, what kinds of things you want to talk about. Tell us, we have got some questions and some multiple choice questions. Tell us a little about your estate, what you want to make sure you address. If you get through that, okay. No, we cover the expense of that first meeting. A lot of the people who end up having those first meetings end up, of course, doing business with us. All right, LD, Steve, I just gave my daughter to help them. Good job. It's okay for you to go past. There is no tax. There you go. Perfect. There you go. IRS Form 709. Nobody owes any tax. You're just letting the IRS know, hey, I gave 50 grand to my daughter. that exceeds the $19,000 or $18,000 limit, depending upon what year you did it, everybody's good. Move forward. Which state prevail when testator lives between two states? Tough question, very broad question, but probably state. There's probably a state of domicile. So I guess that would be it. I have no Tupperware, only collected excellent advice I accept as making good sense. Yeah, I think Tupperware went out of business. So that maybe the Tupperware stuff is really valuable now. I don't know. SLAT, how does that work? Yeah, you're going to see a lot of people this year set up their spousal lifetime access trust. It's a way for Fred Flintstone to use his $14 million exemption now, but he doesn't like the concept of never having any access to that $14 million after he gives it away. So he gives it away to a trust, and his wife, for example, gets the income from that trust for her lifetime. And so he used his $14 million exemption while he had it. It's a way a little bit to have your cake and eat it too. But yeah, you'll be seeing some more about SLATs in 2025. Paul White, if I give a front, is there a way to have them pay the tax due on the? There is no tax due, Paul White. So a gift of any amount. People mistakenly believe that if they make a gift in 2025 in excess of $19,000, that somebody owes some tax. A lot of people think the person who received it pays tax on the amount that they got in excess of $19,000. That's not the case. So if you give your friend $119,000, there is no tax due, but you have a responsibility to file a gift tax return, IRS Form 79. Show the IRS that you used $100,000 of your estate tax exclusion amount, but you won't send a payment in with that gift tax return. Do my husband and myself need an EIN? Actually, no, you don't. Let's see. Even though we do not have a business or part of an LLC regarding Oklahoma. So I don't really get what the last part was, but people who set up revocable living trusts and then they go set up their trust account at Schwab or Fidelity or the bank or whatever, they are to use their social security number as the tax identification number or employer identification number for the trust. So a revocable trust, because it's a grantor trust, it doesn't need its own EIN, or sometimes people call it TIN. Same thing, employer identification number or tax identification number. You know, I've got to look at some really, really good questions today. It's quite high. States have lower. Yeah, some. So a handful of states have their own estate tax have their own estate tax. What we've been talking about is the federal estate tax applies to everybody. Doesn't matter where you live. But some states, a handful, have their own estate tax or inheritance tax, and the exemption amounts are often much lower than the $14 million federal exemption. Now, the rates, if you do exceed, let's say your state has a $5 million state estate tax exemption, in most states that have an estate tax, the estate tax is not going to be 40% like it is at the federal level. It might be 10 or 12, or, you know, again, I hate to even say because every state is different. All right, good question there. My sister is not happy with the terms of my deceased parents' irrevocable trust. Can she sue to have this changed? So, yeah, I mean, that's a loaded question, but I get that question a lot. Hey, my parents did this in their will or their trust, and can somebody just, after my parents die, change the terms of all of that? And the answer is always no. So now sometimes there are disputes about how something is to be interpreted. And so sometimes there is, there's estate, those things need to be resolved. But no one, if a parent said, I leave everything to my 3 children equally, no one has the right to go in and after the parent dies and say, yeah, I think I'll change that. I think I'm going to change my parents' stuff so that 100% is left to me. That just, no, doesn't happen that way. All right, Stephen, complimenting Elle's question. Good. We put in our will that anyone, okay, there you go. So that's the old no contest clause. So if someone does contest the validity, then most no contest clauses say that person gets nothing. So that can really dissuade someone from challenging. Every state has its own rules on whether these no contest clauses are legal and valid. So, but even in a state where they're not enforceable, often they have some beef to them. Paul, what can someone do if the trustee refuses to give a copy of trust? Well, now you're probably going to have to file something at the courthouse to require that the trustee do what they're supposed to do. And most state trust codes and even many trust instruments require that the trustee provide a copy of the trust to the beneficiary. So hopefully you get that resolved. I need to Zoom with you, Mike. Good. Are under HIM standard. Okay, so now things were left to irrevocable trusts, and it sounds like the trustee has the discretion to make distributions to the beneficiaries for their health, education, maintenance, and support. Very common HIMS standard. All right, great one, Stephen. So look, hey, that was a good one. Stay tuned. Got more coming. Your questions trigger different topics that I'm going to be producing some live streams on. This was all good stuff. Y'all have a great day. Take care. See you next time.